Well, hello, everybody, and welcome. Sorry, we're a couple of minutes late. We ran into a few glitches getting things set up, but we seem to have ironed those out. So I thank you all very much for your patience. My name is Tim Sink. I'm president of the Greater Concord Chamber of Commerce. And just a couple of things as we get started this morning. First of all, and I think you're all doing this anyway, but just a reminder to mute yourself until we do the Q&A so that we don't have any sound distractions in the background. And the only other thing I'll mention is that we have a lot of events coming up at the Chamber, and I won't go through them all, but I will mention that our annual business showcase is coming up April 16th at the Grapponi Conference Center. It's a trade show, and we'd love for you to take a look at that and consider exhibiting at a booth. It's a very popular show and it'll be lots of fun. So those are my two announcements, and then I'm ready to get going on today's program on understanding the Corporate Transparency Act. And we are really fortunate to have Attorney John Cunningham with us today to walk us through this. It is an important compliance issue for all businesses, and there are some consequences for non-compliance. So you're very smart to be a part of this webinar, this meeting, and this is being recorded in order that you can come back to it. It'll be posted on the Chamber's website, and we can get this out to the membership at large. So just a little bit background, John Cunningham is a nationally recognized Section 199A and LLC lawyer. He's licensed to practice in New Hampshire and Massachusetts, and he represents clients in other jurisdictions under local rules. He's one of the few attorneys with substantial knowledge and practice expertise in working with clients on both Section 199A and LLC matters. He's written books on how to maximize tax deductions under Section 199A and how to effectively draft LLC operating agreements. And he's currently working on a book titled The Corporate Transparency Act, A Practical Explanation. So at this point, I'm going to turn it over to John to walk you through this, and we'll take some questions at the end. So John, it's all yours.
Okay, thank you very much. I trust everybody can hear me okay. I'll assume that's the case. I have an outline here into which I put a lot of thought, and my goal has been to just make every point that I think New Hampshire business owners, members of the Chamber should know about. And I understand that the Chamber will be sending this outline to you. I want to mention that the Corporate Transparency Act, in my view, is very important for every New Hampshire business owner to know about. It's also pretty damned complicated. And in fact, I've finished the book that Tim mentioned about the act and hope to publish it quite soon. And what I'm going to do now is I have a little timer in front of me that says 30 minutes. And of course, the Chamber can terminate and open up Q&A a little bit before that. I'd welcome that if that's what they want to do. I don't think I'm going to be able to get through this entire outline. Maybe I'll surprise myself, but I urge you, all of the attendees at this seminar, to read the outline if you can stand it. It's not very exciting, but it is, I think, comprehensive. And if you can read that and understand it, and I've tried to make it very clear, you'll know what you need to know about the Corporate Transparency Act. First of all, what is the Corporate Transparency Act? It's a new federal law that requires virtually all owners of entities in the United States to send reports to an organization called, I always have to read the full name here, the Financial Crimes Enforcement Network, which everybody abbreviates FinCEN. So the idea is that the CTA the Corporate Transparency Act, requires virtually all American companies to send basic information to the FinCEN website. And there are various deadlines about when you have to do so. Entities already formed before 1/1/2024 don't have to send in their information to FinCEN until at the latest 1/1/25. Entities formed during 2024, there'll be probably a couple thousand of them, new entities in New Hampshire, have until 90 days after their formation to send in their reports. And the way you access it is you access the FinCEN website. It's, let's see if I can go from memory, www.fincen.gov/BOA, but this is BOI. This is in my outline for you. And then if you've got a PDF capability, which most companies will, you get a PDF form from them, and you fill out the initial report that is due on the dates that I've just mentioned a minute ago. And you have to give information about your company, 3 or 4 points. You have to give information about your owners of interests in your company, and you have to give information about your managers and the people who run your company, and you have to give information about the individuals who have filed your documents that created your company. So that's the information. It's all information which is likely to be readily available to all New Hampshire businesses. And so the question is, why the heck does the federal government require us to file this information? And is the information going to be confidential if we file it? Because some of it, like the names and addresses of the managers and owners, they may not want this to be reachable. Well, I'm happy to say it won't be reachable. But the reason for the law, and it's important that we all understand this, is the following. The federal government is concerned that bad people, they happen to call them malign actors, a somewhat weird phrase, but that's the CTA phrase. They're concerned that bad actors could either be using their entities to violate domestic laws, for example, laws prohibiting money laundering, and they want to know about the owners of those companies, and they're concerned about foreign entities forming U.S. companies, say Russia or Iran or Iraq. I guess Iraq's okay, or China. They want to make sure that they know who really owns these companies, because if they're able to require by law that the true owners, not just the owners that are listed in company documents like LLC operating agreements, if the companies are LLCs, but the real owners, which could be some Russian individuals, if they know who those individuals are, and if these individuals know that the federal government knows who they are, then these bad people will terminate or liquidate their companies, and they won't form them in the future. Now, whether that's actually going to work, only God knows, but that's what they're trying to do. They're trying to find out not just the nominal, or as I call it in the outline, the ostensible owners of these companies and the ostensible managers are, but who the real owners and the real managers are. And sometimes this may be difficult to find out, because it may list in the company documents that the owner is a particular trust established for legitimate estate planning reasons, and that and therefore the owner is the trust, but the owner is not the trust for purposes of federal law. The owner is the trust executor in all probability. So this is an honest but misleading characterization of the owner and manager of this LLC listed as owned and managed by the trust is. But there could also be evil people who conceal their identities, Russians, Chinese, money launderers, etc. So the purpose of the CTA is to catch those people, and the Congress, which enacted the law, of course, is hopeful if these people know that that the government, the federal government, knows who they are, they'll liquidate their companies and they won't form companies in the future. So that's what the CTA is all about. The government has stated, the federal government, that there are 32 million American companies that are subject to the CTA. And the irony is that almost all of them are legitimate companies. Like I'm positive, every company, New Hampshire company that's listening to this webinar, completely legitimate, and whatever it says in their, for example, LLC operating agreement about who the managers and owners are, that's the truth, and that's what you report to the government. But it's possible that there are, well, the government thinks it's likely that some of these entities, at least nationwide, are owned by bad people. So I hope I've been reasonably clear about the purpose of the CTA. I do want to urge you to read this outline, because I'm pretty sure I won't be able to cover everything in it, but the outline is, I hope, in clear, plain English. And if you read the outline, and I'm thinking even 20 minutes of devoting your time to the outline, you'll have a very good basic idea of the CTA and what it means for your company. Why do you even want to bother with this? Well, first of all, it's kind of a patriotic duty to do what the federal government says. But in addition, there are potentially very serious civil and criminal penalties that you can incur if you don't file these reports. It'll be an initial report. They call them business ownership reports, BOIRS. You file an initial report by the deadlines that I've mentioned just a few minutes ago. And then if there's any changes over time, like one of your owners dies, or you admit a new owner, you have to report that in a subsequent report. And it's rather easy to file the initial report. Let me take this call. Hi, Amanda. Thank you for calling, but I'm in the midst of the seminar. Everything seems to have worked out. I'm going to hang up. Thanks. Bye. So that was a lawyer that I work with on matters like this. But the point is, the difficult part is, okay, when do I have to file my updated reports? And how am I going to know when I have to file these things? Because if I don't file them, and there's a random check by FinCEN, this federal agency that handles CT matters, I could be subject to criminal penalties. And one of the companies that provides filing services for a fee has claimed that that the way FinCEN operates is, if they think you owe a report and they think you haven't filed it, they're just going to impose the penalties on you, period. And then it's up to you to prove that you have filed the reports and that you're not subject to the penalties. So there's a strong incentive to make sure you file an accurate report But beyond that, to file any changes in ownership or any changes in management, and sooner or later there are going to be these changes. So what do you do then? Well, the answer is you need you need some kind of internal system in your company that pretty much guarantees that if these changes occur, someone in the company will be responsible for knowing about them, and they'll file updated returns within 30 days after they know or should know about these changes. And exactly how you document what you might call the CTA updated report guidelines is tricky, and it varies from company to company. So it may make sense for you to hire a CTA lawyer. I'm one. The CTA is one of my two specialties. It's LLCs and the CTA. But I'm sure there are other skilled and knowledgeable CTA lawyers in New Hampshire that your own lawyer can tell you about. But the point is, what you need for the CTA lawyer is to set up guidelines for your company that can be attached to your operating agreement if you have one. It can be a freestanding document, but you've got to have this document if you don't have an operating agreement. And it will do whatever is possible in the circumstances of your particular company to make sure you know when an updated report is required and that you file that. And you've only got 30 days within which to file it. It's a ridiculously short deadline, but that's what you've got to do. Okay, so I'm looking at my outline. And we've talked about the impact of the CTA. The impact is that it imposes filing duties on companies like yours, and you're going to have 30 days within which to file the updated reports. There's an initial report and there's an updated report. Okay. Sorry about this. John Cunningham. I'm sorry, who is this? Anne, I have to call you back. Thank you very much. I'm in the midst of teaching a webinar, but thanks a million for your call. Bye-bye. Sorry for all these calls. So I've written this book. I hope to have it published by perhaps my current publisher of my LLC and 199A books, Walters Kluwer, perhaps by the American Association. Maybe I'll just publish it myself, but you may want to acquire the book. I've told you Congress's purpose for enacting the CTA. I've told you the affected businesses, basically every business in New Hampshire. We've talked about that. We've talked about the dates by which you've got to file your reports. It's worth going over these dates just quickly, although we've mentioned it before. Companies formed before 1/1/24, you have to file by January 1, 25. So you've got a long time to file. Companies formed during 2024, you've got 90 days after the date of your formation. So it's a fairly comfortable 90-day period. Companies formed on or after January 1, 2025, you've only got 30 days, a very short deadline. What is this organization I'm describing as FinCEN, namely the Financial Crimes Enforcement Network? It's a bureau of the United States Department of Treasury, a major U.S. department. It's a bureau that handles CTA matters for the U.S. Department of the Treasury. My guess is they've got a few hundred employees. They've got this website that you have to access using the URL, the website address that I've just given you. And if you've got a PDF, it's pretty easy to file your initial report. But as I've mentioned, the key thing is to make sure you don't miss your your updated report when there are changes. And of course, if you realize, oh my God, we made a mistake in our original report, or in any report you file, you've got to file what they call a corrected report. So there's these updated reports and these corrected reports, which have to be filed with FinCEN. Okay, there's that. The information that you have to file in these reports about the company, it's pretty simple. What's the full legal name of the company? Does it have any doing business as names, and what are those names? What's the complete street address of the principal place of business? Sometimes you don't have one yet, so you have to do a workaround. In what state were you formed? In the case of almost all the companies in the chamber, it's New Hampshire, of course. And then what's the employee identification number or alternative tax identification number of the company? This, of course, is very confidential, but the CTA rules state that FinCEN can't disclose any information that it receives in a report filed with it by, for example, a New Hampshire company, except to FinCEN employees, of course, or to other agencies that really have a need to know that information. And the information is maintained at the highest level of secrecy available to non-classified information. And this is a very high level, not as high as if it's, military secrets, but high enough that you can be quite confident that whatever you do disclose to FinCEN is going to be kept confidential, and your competitors or other people won't be able to find it. So that's a big deal. And then you have to give information about beneficial owners. And there's a trick here that I want to mention to you because it's important. Owners can mean people who own stock or other ownership interests, such as LLC interests. If it's an LLC, they own an ownership interest in their company, but it also includes people who are managers. So this term, CTA term, tell us about your owners, is really quite deceptive. I find it infuriating that it should be deceptive in this way, but it means not only owners of ownership interests, stock or LLC interests, etc., but also people who are important managers of your company. And we don't usually say, oh, he's an owner, he manages my company, because he might be a manager, but not an owner. So this hidden double meaning of the word ownership in the CTA is quite confusing. I don't know why they have structured it that way, but we're stuck with it, and we have to realize that fact. And then there's this kind of implicit, what would you say, assumption of the federal government that there can be ostensible owners, and you look at the LLC agreement or the shareholder agreement and you say, oh, the owners are Joe and Mary. But in fact, the true owner is the people who tell Joan and Mary what to do. So you've got the ostensible owners, and then you've got the real owners, which the CTA calls beneficial owners. Again, not a term I'm crazy about because it's usually a very positive term. Here it's not so positive in some cases. You've got the owners in the traditional sense, and then you've got the substantial managers, and that's what they mean by this term owner. And I find it a bit confusing until you really focus on it. But there's information about the company, information about the beneficial owners, full legal name, date of birth, a complete current residential street address, and identifying number from one of a list of identification documents, starting, of course, with your driver's license. And this is all confidential information. Most owners don't want people to know their name, their date of birth, how old they are, what their current address is, what their driver's license number is. And they don't want them to have an image of your driver's license. That's the fifth thing you have to disclose. And some owners may say, you know what, I'm not giving this information. I really don't trust that it's going to be kept confidential, and it's nobody's damn business. And the problem with that is this, that you've got to make a certification in the information that you send to the FinCEN, that your report is complete and accurate. So if you know that there's an owner who's refused to give this information, you're in trouble. And you got to go to that owner and say, look, we need to get this information from you. It's absolutely required, no exceptions by FinCEN. And if we don't give that information, we could be subject to criminal penalties, but so could you. You don't want to be subject to civil or criminal penalties. It could be $500 per day of withholding the accurate information. It could be a total of 20,000 for a year, or it could be 2 years in prison. You don't want those penalties. If you have any common sense, you'll give us this information. And furthermore, the CTA statute and Congress is telling us that your information will be very confidential. But if they refuse to give the information, it's a problem for everybody. You just have to disclose this refusal to FinCEN, and they might then knock on your door. So then there's this thing called company applicants, which you also have to give information about. And that's the individual who has filed the document with the Secretary of State that created your organization. And in New Hampshire, as you probably know, it's a certificate of formation. If you were formed before 1/1/24, you don't have to provide that information, because it could be that you were formed 20 years ago and no one remembers who the filing person was. But you do have to check with the Secretary of State to see if they've got information, so you can provide that information if it becomes necessary. But technically, you don't have to provide it. But you have to give information about your company. You have to give information about your owners. You have to give information about your significant managers, and you have to give information about company applicants, unless your company was formed before 1/1/24. It's a bit complex. Now, there are various individuals who might be thought to be owners, but won't be treated as owners. And this happens to be paragraph 24 of my outline. And the big ones are minor children, as long as you provide information about who their guardians or parents are. So a minor child might have an ownership. The child would have the ownership through the guardians or parents, but the child is not viewed as an owner as long as as long as you provide the names of the parents or guardians. Individuals who act as nominees, intermediaries, custodians, or agents on behalf of an owner. Why that would be the case, I don't know, but the federal government thinks it can happen. And then employees they call them reporting companies. That's the key term. Those are the companies that have to report to FinCEN this information I've been talking about. And these, if an employee is also an owner, but has the ownership only because of their employee status, and only acting as an employee, and is not a senior officer like CEO, COO, general counsel, etc., then you don't have to report them. And then if you don't have to report the creditors of the company, even if they have a right to ownership if you default on your loan. So there's that. And the initial reports are rather easy to file, and you'll probably find that you can file them on your own by just accessing the FinCEN website. And I've given you the URL for that during this talk, but also in the outline, which I urge you to look at. But the tricky part is filing subsequent reports. And there you've got to have great guidelines that will make it very clear that if there's any change in who your owners are or who your managers are, that you'll report this information to FinCEN within 30 days. The statistical likelihood that FinCEN is going to knock on your door, I think, is scant. But you don't want that to happen, because then you're in this situation where they say, oh, so you've there's been a change, you haven't reported it. That will be $500 a day, please, from the moment when you fail to report it. And we're just gonna find that, impose that fine on you, and then it's up to you to prove that that you didn't owe this, or that you've given us the information, because this is the process of proving this to them could be expensive in legal fees and time and management resources. So that's the essence of what I wanted to talk about. I'd be happy to provide the service, the key service I've mentioned about the document that will ensure that you file if there's any change, and that you file within 30 days. But any good CTA expert can, or I should say, a competent CPA practitioner can help you file those. But in case you want to contact me, my contact information is the final point in the outline. Please read the outline. That's the end. Tim or other listeners, I see that I have 1 minute left. I'm happy to answer questions. It's a matter of what the chamber prefers.
No, I think that would be great, John. I'm happy to take any questions from folks that are here. I'll kick one off really quickly. This filing is for everybody, is it not? I mean, for instance, the Chamber of Commerce is a 501c6 nonprofit. We would have.
That's a great point, and you don't have to file because you've got a federal tax exemption.
Okay, so it's for profit only.
But there aren't that many federally tax exempt entities in New Hampshire. They don't have to file, but practically everybody else does. Now, I should mention, this is a good occasion for doing so, that the CTA itself identifies 23 types of companies that don't have to file. But the most important of these are public utilities and other entities, that publicly traded companies. There are very few of them in New Hampshire, which are already subject to heavy regulation. So the federal government doesn't have to require them to file. But that's a very small percentage of the roughly, I want to say, 38,000 New Hampshire companies that have been formed under New Hampshire law. So if you're a business owner listening to this webinar, I think there's a 99% chance that you better file, and you better do it within the provided deadline.
Okay, so we have Rashe's iPhone hand up. Rashe, would you like to ask a question?
Thank you. Yes, I would. Listening to you, I thought I heard at one point in time that it was only for companies with 20 employees or less. Is that not an accurate message that I received?
Yes, because it's for companies with 20 employees or less. If you're a quote large operating company, which basically means you have 20 or more employees, for some reason the CTA says you don't have to report. So if you've got, this is a great question, because there's probably some hundreds of companies, if not more, in New Hampshire that qualify as large operating companies. But I would play it safe and give a call to a CTA expert about whether you qualify for the large operating company exception, because there's a number of other requirements you have to meet in order to qualify for that exception. But that's a great question, because there's a fair number of New Hampshire companies which meet the technical definition of large operating companies. I hope that answer's clear.
That's very helpful. Thank you, John. Other questions? I hope that you have all received John's outline. It's very detailed and very, very helpful. If you walk through that, I think it'll give you what you need to know to, make sure you stay out of trouble on this. So that's very important. Also a reminder that this is recorded, and we're going to have this up on the Chamber's website. So if you need a refresher or you want to refer somebody to this, they can go to the Chamber's website, concordnhchamber.com, and get and find this and review it at a convenient time. So last chance for any questions from the group. Not seeing any. John, I just want to thank you for this. This was very useful information, a little bit scary, I'm sure, for all of us, but I really appreciate you taking the time to explain this to us, and we'll stay on top of this, and we will continue to provide information to Chamber members and the public at large about compliance to this.
Yep, I'm at the Chamber's disposal.
Thank you much, John, and thank you all for joining us, and we hope to see you all soon, and have a great rest of the day.